Friends, today I am before you. I will be talking to you about one of the most important topics which concerns all the government servants. And the issue is of issuance of the vigilance clearance, which concerns all the government servants at all levels. Friends, the issue of vigilance clearance assumes greater importance when a person is due for promotion or when he is due to retire and the question of disbursement of his retirement benefit arises. In these situations, friend, the issue of the vigilance clearance issue assumes greater importance. Friends, vigilance clearance can be withheld in the following 7 situations. When the government servant is placed under suspension, when the government servant has been placed on the agreed list. Number 3, when against the government servant the disciplinary proceedings have been initiated and those disciplinary proceedings are pending. Number 4, when a charge sheet has been filed against the government servant in the court of law. Number 5, when the FIR has been filed against the government servant. Number 6, when the orders have been issued for initiation of the disciplinary proceedings or launching of the criminal proceedings against the government servant, and within the period of 3 months the disciplinary proceedings are initiated or the complaint is filed in the court of law. And last, when the government servant has been subject to trap, obviously in corruption cases, or when he has been subject to such action. These are the 7 situations in which the vigilance clearance is not issued to the government servant. Friends, even if the criminal proceedings are over, even if the disciplinary proceedings are over, still the vigilance clearance cannot be issued. The period after the closure of the disciplinary proceedings, within which the vigilance clearance will not be issued despite the closure of the disciplinary proceedings, is known as the cooling off period. And this period, in the case of minor penalty proceedings, is 3 years. Means, if today the penalty has been levied on a government servant, for next 3 years, the vigilance clearance will not be issued. B, when the government servant has been levied with a major penalty, even if the period of major penalty is over, for further 5 years, the vigilance clearance will not be issued. Thus, friends, in my opinion, my advice to all of you would be, take the disciplinary proceedings very seriously, because the disciplinary proceedings, generally the experience shows, takes 10 years for its closure, for its culmination. And even if the disciplinary proceedings have been closed for further 3 years or further 5 years, the vigilance clearance cannot be issued. And what actually happens is, supposing that these proceedings take about 10 years and the major penalty has been levied, for further 5 years the vigilance clearance will not be issued. That means virtually the entire career of the government servant is over. And especially in the context of the Group A government servants, the senior government servants, it is in their interest that disciplinary proceedings should conclude at the earliest possible. Because once the disciplinary proceedings have been initiated, even if it get concluded later on, his career would be over. So my advice to all of you would be, kindly take the disciplinary proceedings very seriously, so that the vigilance clearance is also issued to them without any hitch in their career. This will be helpful to them. This is all I wanted to speak to you today about the concept of the vigilance clearance, which assumes greater importance in your life. I hope you would love the content. Thank you.